IP, and today is going to be all about patents. We have 3 patent panels. We're trying something different here today. Normally I don't like having more than 4 people on a panel, and what you see is obviously more than 4 people. But what we have is, and when Z is here to help me moderate and really going to do much of the moderating today, and I worked on creating this segment and the next segment with her, and I decided at her suggestion, it was her idea, that what we would do is we would talk about how do you actually draft patent applications to satisfy 112 and 101. And then the second part of it is, okay, now that you have the application filed, how do you actually get it allowed when you're making arguments with the examiner and all the procedural and process-oriented stuff. So rather than having 4 people on the first panel and a different 4 people on the second panel, we decided we would have all 8 on a roundtable discussion, since it's hard to distinguish where the drafting ends and your strategy for prosecution begins, because you probably have to think about that while you're drafting, particularly in the spaces where the examiners are examining AI applications, which some of the allowance rates may be not so great, some of them may be better, but there's a lot that goes into it. So we're going to try and have a holistic review of this from start to finish with a bunch of people who've thought about this from a variety of different angles. So what I'd like to do is introduce our panelists, and we can start with, from the audience's left, we have Dan Radoy, and he is a shareholder at Wolf Greenfield, and he focuses his practice on IP counseling, patent portfolio development, and patent prosecution for clients developing technologies in a wide array of areas, including for artificial intelligence. Thanks for being here, Dan. Next, we have Suman Dasgupta, and Suman is a principal of Jordan IP Law, and he's involved in all aspects of patent law, including patent and portfolio management across a variety of different areas. And you also just co-authored with the next speaker, it was IPO's Artificial Intelligence Guide, I guess you would call it, right?
Correct, just released last month.
Great, thank you for being here. And then sitting next to Suman is Mike Carey, and Mike is a member of F. Chow and Associates, and his focus is on the area of artificial intelligence specifically, and with an emphasis on generative AI and computer vision. And with Suman, he co-authored IPO's AI guidebook, I guess you would call it, right? Is that what you guys called it?
AI white paper.
White paper,
yeah,
okay.
Patent drafting handbook.
Great. So thank you, Mike, for being here. Next to Mike, we have Drew Hirschfeld, and Drew is a former longtime commissioner for patents. He, at the end of his career at the Patent Office, became acting director for about a year between administrations, and now he is with Schwegman, and he is primarily an expert witness on all things related to patent prosecution and all the things that we need experts to testify about, including inequitable conduct and all that sort of thing. So Drew, thank you for being here.
Thank you.
Next to Drew, we have Dina Blinkenstein, and Dina is a partner and co-chair of the Artificial Intelligence Practice Group for Haynes and Boone. And Dina has been here speaking with us before many times, so thank you, Dina, for coming back. We really appreciate it. Her practice focuses on all areas of technology, including cloud computing, cybersecurity, and of course, in addition to AI and machine learning. So thank you, Dina. Next to Dina, we have Rob Kerloy, and Rob is the lead counsel for intellectual property at OneTrust, which is a market-leading trust intelligence platform provider for enabling collaboration across multiple trust domains. And prior to joining OneTrust, Rob spent a lot of time practicing in this area specifically, and he had spent a decade at Kilpatrick and Townsend. So thank you, Rob, for joining us here today. And then last but not least on the stage is Brian Walker. Brian is IP counsel for 3M, And along with developing and managing international patent portfolios, his practice includes patent opinion work, trade secrets, generative AI, licensing, and contracts. So thank you, Brian, for being here. And then the moderator, the principal moderator for the panel, and someone that we have had on many of our panels and has done a lot of work with us here at IPWatchdog. She does a vlog series for us, and she writes articles, co-writes articles with me occasionally when she can corral me into cooperating. I told her that I haven't been the greatest friend lately. I realized right before events I try and go through my email box and get to the bottom, and there was a number of ones that I owe Wen, so I'm sorry. But Wen Z, and Wen is a partner with Global IP Counselors, and she's a prosecutor, and she works in all areas dealing with software, but specifically deals with with artificial intelligence. So I'm going to turn it over to Wen. When these conversations were your idea, really, can you give us an idea, just generally speaking, what was it that you want us to hopefully accomplish over the next couple hours here?
Yes. Oh, thank you all so much for being here. I'm really looking forward to what everyone has to say. You know, as an emerging field, I feel like we're all learning, and it's a great opportunity for us to all learn together, and you know, for us to pick each other's brains on all topics. I feel like with AI, in my practice at least, it's like something new all the time. You know, I have a new problem all the time. Recently, an inventor, I was telling some of the other panelists, oh, it's like a neural network, but it's not. So what do we call it? A neural network-like thing, like framework? And I said, no, I can't call it that. But it's just issues like that. Now we have the 112 guidance and the AI guidance, and the practice just is constantly evolving along with the technology. So I guess what I would really like to get into is, what do you, for the panelists, who do you guys follow? How do you stay on top of this field? How do you continually study and to be able to, you know, practice and advise your clients? I think we could just go around and start with Dan.
Sure, I can go first. I think there's a lot to study. I think what doesn't work is just assuming you're going to learn from the matters you're handling. I've tried that on occasion, and that's just too difficult. I think on the substance, I try to read like machine learning, AI, actual technical developments. So there's newsletters and kind of blogs I look at, papers that have received some accolades. I try to read them. I try to also, when working with clients, just offer time for free to come, and they think it's great for them, but it's great for me because I can spend more time with inventors and kind of like learn. So there's sort of the technical piece, and then of course all of the legal stuff, staying on top of case law, you know, guidance from the patent office. That try to do that at a regular clip.
And Suma, do you find that your invention disclosure process has changed at all with AI and ML? Is it longer, your interviews with your clients and inventors?
Yeah, I think it certainly has. You know, I think a lot of that stems also just from the whole 101 sort of debacle we're in right now. But particularly with, you know, machine learning and AI, I find a lot of inventors kind of have a narrow perspective on what their invention is. But when you kind of peel away a bit at what they're actually doing, you'll find that it's broadly applicable to not just one particular area or sector. It's actually applicable across the board in many different arenas. So that's one thing, is sometimes they underestimate just how broadly reaching their inventions are. And I think also it's very important that, you know, I know this whole panel is supposed to be about enablement, but one of the things I like to parse during these interviews is also just, you know, hey, what are, you know, the inputs? You know, do you know, just give me a brief overview, you know, what's, you know, going into this, what's coming out. Try to make it a little bit clear in that sense. I'm sure we'll get more into it, but I try to address some of those matters up front also with machine learning, because it is so complicated. When you speak to some of these inventors, they actually don't know what's happening on the inside of these models, so we have to try to figure out as much as we can and what should be kept trade secret versus what we should put in for enablement and other such issues.
And who do you follow and to stay on top of this field?
Actually, I'm kidding. I actually follow quite a few people. So, you know, there's normal websites, you know, they'll visit, like IPWatchdog, of course, you know, Patent Leo and so forth for some of the more legal issues. I find a lot of my greatest experiences in learning has come actually through trade associations like IPO, and being an active member of some of their AI and emerging tech committee, involvement has been very helpful for me just to learn. So, as Gina was pointing out earlier, me and Mike over here did the whole white paper that was just released. And I think for me at least, I was really instrumental in forming some solid opinions in terms of artificial intelligence, because you got to work closely with these practitioners who have vastly different viewpoints from you in different industries and in very different roles. And so you get to hear it not just from the prosecution, but from corporate counsel, like what are they looking for? How do they view this? And what are they doing on the inside before these invention disclosures even go out? And it helps us to understand, okay, maybe these are some more aspects we can even look into. But just learning from my colleagues has been very helpful in terms of navigating these new fields, because it is emerging, lots of new issues, and I think we have to keep an eye on case law. It's going to evolve. So I think that's been one of the strongest points of learning for me.
Yeah, evolving technology, evolving practice, and evolving case law. So we have to keep all those balls in the air, when we draft an application. Mike, you worked a lot on the IPO AI handbook. One of the things I felt was really, really helpful was that it was sort of segregated in terms of different types of AI. How do you write for a training claim versus an applied claim? Do you feel like your background as a software engineer really helped you be able to do that?
Yeah, although a bit of a correction. So my background is more like in math.
Okay.
And
I'm sure that helps.
no, it's one of the. I love working in AI because I look at the papers and I see an equation, and just like everybody else, initially, like, I think it's pretty universal when you see like equations and stuff to just be a little put off by it. And being a mathematician means you can overcome that initial disgust and fear and loathing and then dive into it. But then there's light at the end of the tunnel. And I really do love kind of just like working through, especially if you're working on some cutting edge technology, like trying to understand like what all the different pieces mean. I think that being in an emerging field like this, it's the best place to be as a patent attorney. It's really fun. It's really exciting. There's so much to learn. And so in addition to plugging the IPO, AI, and Emerging Technologies Committee, which I think has been really important for me to keep up, another advantage is it just so happens that we're in a field where there's a lot of like interest in popular culture, and there's a lot of things going on that like people are actually afraid of AI. One of my favorite, just like, cultural side blogs is called Don't Worry About the Vase. It's this very nerdy kid who's just keeping track of like every single development in AI, and there's a lot of interesting stuff to read, just like in terms of the cultural impact of our industry that we just happen to be at a moment where that's super relevant, and it's fun to keep up with that kind of stuff as well.
Yeah. Who do you follow to keep up with the culture?
Yeah, the one I meant. So the blog called "Don't Worry About the Vase." If you haven't read it, go look at it. It's pretty intense.
And who is it written by? Is it by an inventor or an engineer or someone in the
a software developer in the AI field? He goes by the Zvi.
The Z. Okay. Yeah, I'll have to look that up, because it's one of the things I struggle with is the jargon, because they're their own lexicographers too. And I'm just like, and sometimes you don't know what you don't know, and I'm just trying to think. I think that's what you meant, but you have to ask a lot of questions in your disclosure interviews now, because you want to make sure, but without sounding too ignorant. I try to make it seem like I think this is what you meant, right? There's a lot of that.
Yeah, and you have to be able to communicate that too, because you get on a call with a patent examiner, and it's not uncommon. I'm talking with a patent examiner who has never dealt with an AI case, and the patent is full of jargon because a lot of technical language, and not only that, but sometimes we write things to kind of obscure them or abstract them, and so it's like you have to know your audience and be able to talk to the inventors, and you have to be able to talk to the examiners, and and that's part of our job, is to be able to be communicators, to take it in and spit it out in a completely different way.
Mr. Commissioner, can you give us a little background scoop on what the USPTO is doing? How do they keep up? How do they train their examiners when something new comes up like this? It's a new technology. Just tell us.
Well, I saw a hand go up, so I don't know if you want. Do you want to
Sure.
address that? And I'm happy to return your question.
Sure. Sorry to interrupt. It's for Michael. How do you get into a situation where you're on the phone with an examiner that hasn't dealt with an AI case? Is that because it's more of a case you're prosecuting is more of a applied AI case? You're baking a microwave oven, able to cook faster, and they're in the microwave oven art unit, and you have to bring them up to speed on the AI. Is that?
Yeah, there are a couple of ways it can arise, but that's the big one, is because AI is being applied to everything. The other one is sometimes we write an application to avoid a particular art unit. And if we've written to avoid that art unit, who knows where, sometimes you're going to target another art unit, but you might not, it might get into an art unit that, you might try and get it into an art unit that has a lot of experience with AI. But sometimes you'll just find yourself in a random art unit that they chose it for who knows what reasons.
Just a quick follow-up. Is there any trend in the USPTO, maybe Drew would have some insight on this, but towards having multidisciplinary teams of examiners, where one is in microwave ovens and the other is in AI, an AI generalist that kind of gets dispersed out to the art? Do they do that, or do they just have to pick one art unit?
Mm-hmm. That's a good question.
You want me to address that? So,
If you know.
I was asking when. So I can't. I haven't been at the PTO for about a year and 3/4. So I will tell you that my information is maybe a little bit outdated. But I can tell you when I was there, this is exactly something that we were looking at. Let me back up to. I want to address something that was just said about the art unit and how you end up in an art unit. We struggled at the PTO, quite frankly, when AI was new about how were you going to arrange, does this require any different arrangement of art units? Because AI is in every technology, so do you have specific AI examiners, or do you keep them in their own technologies, and then as AI develops in that technology, those examiners learn that? The latter approach, quite frankly, is what the PTO is doing. I can't say that it was necessarily a choice to go that route, but I think this all just happened so fast, and it was no way to really rearrange it. Just quite frankly, didn't make sense to try to say, let's pull out AI from all these different technologies and have a unique area for it.
Because you don't do that with software, right? When your PTO doesn't do that with software, right?
That's correct.
So what you just described is the way that generic software.
Correct.
Okay.
Yeah, and it's the same issue, right? Software can be all over and so wide and so broadly scoped in different technologies that it's really hard to separate it out. To your question about multidisciplinary art units, that is something that we were exploring when I was at PTO. Again, I can't say what's happened in the last maybe year and a half to 2 years almost. I think I don't know if you're all familiar with the Pro Se art unit, which is a unit specifically geared to help people who don't have representation. And it's a multidisciplinary art unit. And there were so many advantages that we saw at PTO to having examiners from all different areas of the PTO and different technologies working together. I do think that is potentially an option for USPTO to go. Whether it's directly for AI type of issues or broader, I don't know. It's probably just going to be done in a broader sense. But that certainly is a possibility, is something that I hope USPTO will explore. I know there's also a new construct. It did start while I was at PTO, but it wasn't actually implemented until after I left, and this is the test art unit. I don't know if anybody's received an office action from I think it's a RD00 or something like that. It's a research and development art unit. I said test, but I think it's technically a research and development, and it's a way that they're trying new things out. I'm hoping to see more information out released from the PTO on this, but I know they're just getting this started. To me, something like what you said about multidisciplinary areas that this art unit probably is, and maybe that's something that they're testing, and hopefully they are.
Suman, you had something?
Yeah, I was just going to make a quick note that in some other jurisdictions like Japan, when artificial intelligence first started to come to the forefront, what their approach was, they would take like an expert in AI and embed that into several different art units, so they'd have a different AI expert, and that AI expert was responsible for sort of explaining some of the nuances of AI to the other examiners and helping them in that multidisciplinary approach, particularly with these applications of AI. And I think it's proven fairly effective in some of those jurisdictions. We've gotten pretty positive feedback in terms of prosecution quality there and their understanding of artificial intelligence. But I would love to see a similar such approach here if it can work elsewhere. Perhaps it could work here also. At IPO, we did host like a full kind of training session for examiners a few years ago. We had maybe 600 or 700 examiners show up to try to listen in on what artificial intelligence is and to gain some sort of insight in what's going on. And a lot of them did not come from AI-specific sort of art units. They came from like very different art units. So there's a tremendous amount of applications of AI out there. It's flowing to a lot of different areas, and there's a huge interest. I think generating that sort of training level for examiners is, of course, going to be challenging, but there's multiple approaches to this, I think.
Do you happen to know if select examiners are being selected to be trained in this way to examine AI, or are they just trying to apply it across the board?
I think it's attempted to be applied across the board and as needed. I think it was, and again, maybe somewhat outdated information, but I think it was challenging to identify where the AI applications are going to be and who you would have to train. I really do like the approach of an AI expert that could help out in an art unit to help people come up to speed on an as-needed basis. I think it's a great idea, and it seems very workable to me. But I think from a logistical standpoint, with hundreds of thousands of applications coming into the PTO. You don't know where the AI is going to be. How do you get your examiners ready? I think it just has to be real time coming up to speed.
Yeah, so the transition must be a lot slower, because one day the examiner has to put on his mechanical hat, and the next second, the next case he might have to put on his AI hat, and then to assess the claims a little bit differently. So it might take a little time for them to be able to become accustomed to looking at prior art and all that somewhat differently.
I think it's going to take time for everybody involved on all sides of the prosecution.
Dino, tell us, who do you follow and keep up with?
So I follow a number of things. I go to conferences quite a bit, the technical conferences, such as AI4, AI Summit. There's an AI Summit in London coming up, and also specialized conferences in, say, healthcare and finance. And what I found very quickly, the conferences allow you to stay on top of the technology, and you figure out which way the technology evolving. And the way it's evolving in healthcare is going to be different than the way it's evolving in finance, for example. So on top of that, once you start going to conferences, it will reflect in how you draft patent applications, because you'll be drafting with an eye for the future.
It's interesting that you mentioned that, because about how it develops in different fields. I know in this conference we talked a lot about use claims and having use claims, but I was thinking, I don't know, for my clients, I think it would be very difficult to identify use for my particular clients. So you obviously have to think about that for different types of technologies, which would be, not only do you want a claim that could stand up, but something that is enforceable and detectable.
You have to figure out what's enforceable and detectable, but you also have to figure out what the industry is like, and try to draft claims that can be directed at competitors' products. Right. So it's almost like it's an equation of how do I draft a patent application, but also how do I draft a patent application that my client can use in the future once the patent is allowed.
Rob, tell us about how things are going in fintech and AI, and who do you keep up with?
Well, obviously I follow IPWatchdog and the other standards, your Patent Leo. And I also, it's a little bit more basic, but I have news alerts set up in Lexology for patent issues across the world, and every morning I get a nice little email with aggregated stories from across different places. And also just follow former clients, follow CTOs of companies I've done patent work for in the past. I follow a lot of our R&D folks at OneTrust, and that's just overall that I think that gives me a way of keeping on top of both the legal side and the technical side. How are things going in fintech? I mean,
Is it easy or just?
Is it easy?
Yeah, I mean, getting your applications on. I would imagine they're quite difficult because you have talked about trying to draft in terms of getting it into particular art units. I've honestly never really attempted, so maybe you could give us a couple of tips. Is it claims and drawings? I would imagine.
So. The reason, and I think when we've talked, you've mentioned you've typically worked on AI within the context of a mechanical system, and I think, and even in other cases where you're working on AI in the context of things like image editing and video editing, when there's some federal circuit case that's really on point with your use case, it's easier to just stick to what the inventor told you. I think, and the problem is in the fintech space, and that's things like authentication or risk management, or say business intelligence. At least where the case law is right now, there's no federal circuit case that's fully on point that tells me, if I have groundbreaking innovation in the AI space, but it's applied to targeted advertising, that is patent eligible. And so that, for that reason, in order to get these innovations in front of examiners who are more likely to, I'll say, give it a fair shake, who have, who are more experienced with dealing with AI issues, who are not immediately going to reach for 101 just to, I'll cynically say, get their counts up, then yes, you have to draft a little bit more strategically. And one thing that involves is the claims. The way I tended to do it was I would start with a claim, I would feed it into something, back then, this was 3 or 4 years ago since I've been in-house for a while, but I would feed it into something like Patent Advisor to give me a predicted art unit. And that'll give me 4 or 5 art units, and I'll find which ones are probably most on point with the invention.
Oh.
And then you go back, you look at the definition of the class that gets fed into that art unit. You pull language from the class definition, and you build it into your spec wherever you can. You build it into the technical field. You build it into the background. You build it into the summary. The first few pages of your application, to the extent that you can integrate language from the patent class that feeds into the art unit that you were looking for, you're going to set yourself up for success.
That is really interesting. I personally never thought about that. But so you basically become you look for particular words or terms that an art unit is more prevalent in the different art units.
Yeah, and that's I found that I don't know if I was always successful in hitting the art unit I wanted, but I at least landed outside of 3600 series art unit, which is honestly the best you can hope for.
So is that just the goal, is to get it out of 3600?
I mean, I think the goal would be to hit the art unit you're aiming for.
Okay.
But I think as long as you land outside of 3600, you certainly got a better shot.
Okay.
And I think I know I've talked a little bit here, but the last point I want to make is that when you are targeting for an art unit, you're going to deviate from, I think, what a lot of us were taught as a best practice as a patent prosecutor, which is the inventor needs to recognize their invention within the patent application. It's a great guideline so far as it goes. But if hewing towards the inventor's way of describing the application is going to divert the patent application into an art unit where you're never going to get a patent, then you need to step back a bit and say, how can I best serve my client? And if that means deviating from the inventor's language, I'd say that's fine, as long as the invention is still within the scope of your claims. But you do need to prep the inventor that is what you're going to do. You need to have some explanation of patent eligibility at a level of abstraction the inventor can understand. Don't say abstract idea. That's not going to mean anything to them. It barely means anything to people in the legal field. Just have some quick way of explaining the strategy behind dealing with eligibility that you can convey to the inventor, so they just don't think that you misunderstood their invention.
Can I just add to that? Because you picked
please.
up on a great thing at the end. Getting a patent through is one thing, but a lot of the reason for certain kinds of clients, especially startups, is to be able to take these things, show them to investors, show them to C-suite people, not even just the inventors. And so if you, like I've been in circumstances where we could draft an application in a way that maybe will grease the skids at the patent office to a degree, but if it becomes unrecognizable and investors are looking at it like, what are you patenting? This isn't even your technology. Like, you're telling me you're protecting your stuff, but I can't understand this. Then that's sort of another sort of equation in the variable. So there's no such thing as a single perfect patent document that serves every purpose in an optimal way. We've had situations where we've drafted multiple applications written differently for different purposes, and if clients want to invest in that and that makes sense for their business, it's a good way to go.
Yeah, and the thing I've noticed about a lot of AI inventors is that they all like to write these really long prose language describing their invention, and I'm used to the mechanical guys who are just like, here's a drawing and I'm done, go read this drawing. But yeah, please.
I didn't mean to interrupt you. I wanted to address some of the points that were raised, if that's okay. I know you're still making it around, so I don't know if you want to finish going around, but I want to talk about the PTO classification system, because I think that's important here.
Yeah.
So first of all, and this dovetails a little bit with a previous question about art units and getting an examiner with some experience in AI. The USPTO in the last 3 or 4 years has a brand new way of classifying applications. They are using actually AI to help classify their applications, but it's all based on an examiner's profile now of their past work. So theoretically, the way this should work is that if an AI invention comes into an art unit that had no AI previously, then, and it's classified correctly there, assuming that that's correct, then some examiner is going to get that, and they're going to have the experience sort of on their profile about doing an AI case. The next case that comes in, which classified, which has AI, will get matched to the profile of the examiner, and so they'll have a profile, a technological profile of the case, and every examiner will have a profile based on their past work, and they'll match them up. So theoretically, the AI cases should start to go to the same examiners over and over again, because their profiles are matching.
Yeah.
So that would help. That was one thing I wanted to say about the classification system. The other thing I wanted to say is I wanted to echo the words about using the USPTO's classification system. It's actually the international classification system. Using those words and definitions in there to help draft your applications. I've done, since I've left PTO, I've done multiple complete panels on these 2 topics by myself, because it is really important. You can go to uspto.gov, you can see what the classification system is, you can see what all the definitions are, and you should be drafting towards those definitions. I mean, I fully agree with the comment that you have to draft what your inventor's invention is, and you don't want to stray too far from that. But when you are choosing words and phrases, you are much better served to look at those definitions, and that will help keep your application focused as best it can to the right art unit that you should be getting.
Yeah, there are just a lot of balls to keep in there. I mean, I had a case recently in which the inventor asked me, why did you, what's up with this title? Why did you call it this? It's not a device. So I was like, I know, but I'm calling it that because it's broad. And it's less abstract.
It's really hard. I get asked all the time, how do you steer to this art unit or away or from this one? It's really hard to steer applications. But I think, the best you can do is use the definitions. It got harder over the years because of this new profile matching. It's not like PTO is just looking at what we used to do as the most comprehensive claim and classify it that way. Anyway, there's a whole bunch of hands up, and I see them because I'm looking out their way.
I'm sorry, I'm looking the other way. I just want to get to Brian real quick, and then I'll get to the questions. But yeah, so Brian, you're at 3M, and it's a big company. Can you tell us a little bit about 3M's filing strategy, what they choose to maybe patent versus keep as trade secret, and maybe tell us a little bit about jurisdictionally seeking U.S. protection along with maybe international filings, if you could give us a little bit.
Sure, absolutely. What was the first part of the question again?
Whether to keep
Oh, trade
patent
secret
or
or-
trade secrets, yeah.
Yeah,
Mhm.
no, that is a decision I have to make, and we have a committee that makes those decisions to, close, keep confidential, keeps the trade secret, what tier of trade secret versus what can be a patent. So it really does come down to, what we envision being able to use, and also detectability. I heard that mentioned. That is a huge part, because if it's purely back end, is it really going to be viable in the marketplace to try and, enforce something that we're not going to be able to find out unless we go into litigation and discovery to even get to that question.
When you see a formula and algorithm, is that necessarily a trigger for you guys? Like, oh, keep that, let's keep that as a trade secret.
It depends on how it's being used. When I came on board, there was a wide variety of AI-related technology that had a lot of use cases in a lot of different areas that I inherited. So I could see the benefit of not necessarily keeping it a trade secret because of the broad applicability. But again, it is case by case, truly.
Yeah, I've had cases in which I told my client, oh, I think we should keep this as a trade secret, but the inventor goes, oh, but we're going to write a paper on this. I'm like, okay, well, whatever. I guess we're going to do that.
Yeah, and I did want to touch on just kind of where applications land, at least for me and some of the training I helped develop internally when I came on board. It's, from my perspective and having been an examiner, is more of where I don't want the application to go rather than trying to specifically target it because I think I'll be disappointed. And mainly just not to single out Technology Center 3600 and business methods, but I think most of the people in this room probably would have had more negative than positive experiences in certain areas like that as opposed to other areas. So it's just, I try and use a Trojan horse kind of approach. I like to think of it, put roots down in another art unit if possible, at least to the, can always modify the claims. And, traditionally the practice had been, at least in my experience there, that the examiner will then inherit the, child application for efficiency purposes. So then we can get to the real claim language, maybe in a continuation or further down the road. But let's just at least keep it out of kind of what I consider to be a black hole in a certain technology center. And
oh, that's very interesting. So you file with the intent of filing continuations.
oh, yeah, I don't like the cement to dry.
Yeah.
If it's a high-value portfolio, I play the long game.
Yeah, and you have ideas already of what kinds of, where the claims will go.
Yeah, it's only the spec that matters to me until everything is dried up and all the continuations are done.
Do you guys typically try to avoid restrictions then?
No, I like the inoculation from double patenting.
Okay.
Even though it's not as big in my space as in life sciences, I like that inoculation where I can get it.
Okay, interesting. And maybe you could just tell us about your foreign filing strategy at all? I mean, with AI, it's very much could be a
It is, and I think fundamentally, 3M has had a lot of success with tangible products, and of course there's digital innovation going on. But I think a lot of the business has very traditional ways of looking at where to file based upon where competitors are, for example.
Yeah.
And we don't know, where a startup may pop up anywhere in the world. We have to make educated guesses with, none of us have infinite resources to do that. So it's just a completely different world compared to, I think, a lot of what 3M has done in the non-digital space.
Yeah, thank you. Okay, questions?
So if you have a question, I can come to, oh, here we go.
Hi. I know that for like chemical and biotech cases, patent bots will allow you to put your claim in and then it'll tell you how to adjust the language or whatever. Do any of you use that for AI inventions?
I do. We use patent bots. We have not that I'm plugging for them, but we do have a firm-wide subscription, and we use that tool as well. It's not sort of a guarantee, but it's just an interesting data point to see how the vocabulary you use changes it. But like ChatGPT, which will tell you, I only know things from 2 years ago, or like Drew, who will tell you, I know only things from 2 years ago, so too patent bots will know only things that, they pulled some data set, they figured out some classification. It's really interesting to hear that, the approach may be changing, and if that approach is changing, then it'll probably be a little bit of a delay, hopefully not too long, until the tools like that, like Patent Advisor, catch up and sort of mirror the true process.
Yeah, you also need to remember that all the tools are different. So you can put the same claim language in different tools, like patent bots versus Juristep, for example, and you will not get the same results by far.
Does your team, do they come and train you guys, or is it sort of like, here you go, you learn as you go on your own?
Well, you can ask for training if you want, but usually we use the tools when we need to, so it's train as you go.
Anyone else?
Any other questions?
I must be very old school because I thought the field of the invention in the specification was what steered or at least it had some role in steering to the particular art unit. But I guess that's no longer the case.
That's correct. It's no. So it used to be, actually, let me be complete here in the answer. What it used to be was the most comprehensive claim is what steered the application, so that when a patent application was filed, somebody at the USPTO had to look at it, make a determination what was the most comprehensive claim, and then choose an art unit based on that. Now what happens is a case comes in, it's given a profile, a technological profile based on all of the claims, and then that profile is matched to the examiner's profiles, which are ever changing as time goes on. So it's really hard to say, I'm going to change a field of invention. I've heard a lot of people say, hey, if I change the title, is that going to make a difference? I don't think that's going to make any difference, quite frankly, based on this new matching system. So it really is the totality of the claims create that profile, and that's what causes it to go to the examiner, hopefully the best examiner based on the examiner's profile.
So I have a question. Along these lines, maybe perhaps you're trying to figure out, there's just some examiners that you don't want to get, right? And so I've always been a fan of track one for a variety of reasons. Now, what I understand the way track one works is, like if you all 7 of you on the stage were in the art unit, and my application is going to go to this art unit, then Dan would get the first track one, and then Suman would get the next track one, and then Mike, and there wouldn't be, what I've been told by examiners is that Dan wouldn't get another track one application until all the rest of you have gotten at least one, and then it starts back again. And what they would explain to me was, and maybe this was just some speed doing it this way, I don't know, but that they didn't want to overburden any one particular examiner with the timelines you have to meet in order to do track one. So like Dan wasn't, so if I file track one and then I file the continuation of my application on track one and another continuation, well now Dan's workload keeps getting pushed back. Is that your understanding of how it worked? Or because that would be one way to try and provoke getting a new examiner,
So my understanding of how it works is what you described, Gene, is a possible subset of the ways you can assign track one applications. I believe that, and I think there's very speed dependent, and they have some leeway, is my understanding. But I believe that what most SPEs are doing is not what you're suggesting, is that there is a smaller subset of examiners whose dockets are maintained at a size that they're able to do the track ones in the time that they need to be able to do them. And so that there's a smaller subset of examiners who do track one applications. Do I want to say that what you described is never being used? I don't think I can say that. It probably is. But I do think there's a smaller subset. I have heard many people say, track one is a way to get a new examiner and a continuation. I know PTO tries to give it to the same examiner, so where there's a parent and then a child comes in, if that examiner if the child comes in with a track one, I believe USPTO is going to want to assign it to that same examiner if that examiner's docket is such that the examiner can do it in time. If not, there's a chance that you get a new examiner in that situation.
I mean, I like track one for a lot of reasons. One of simply is if you look at the statistics, and we've got so many of them now, that you have at least an 8 to 10% increase in allowance rate. So I just trying to figure out why is that, and maybe in part it is because in some art units they do it that way. So, if Dan is like the no patent for you examiner, well, he's only going to get 1 out of every 7.
That would be my profile.
Yeah, that would be your profile. I know that about you. But if it is like there's sort of like this SWAT team of examiners who can handle that, and that they are the go-to track one people, that would also kind of explain the bump, right? And I guess I'm not asking you to explain the bump, but can you like confirm for everybody that that's what you saw when you were looking at data, right? Track one is higher.
There's definitely a higher allowance rate for track one applications. Since I've left PTO, I've been trying to figure this out. So I'll be honest with you, like when I was at PTO, the thought was, well, it's people on the outside are filing only certain applications. If you're going to spend extra money for track one, you've put better resources maybe into this, or it's a more important application. So PTO looked at least I did when I was at PTO, looked at this as something the applicants were doing. Since I've been on the outside and talked to people, I think sometimes that's true, but I've talked to a lot of people that say, no, we don't write any applications differently for track one than we would for anything else. We think it's the examiners are different because they're maybe more senior, it's people who are used to track one. Honestly, it's probably a combination of both is a little bit true, but it's definitely a higher allowance rate.
Yeah, and that's the thing that you just need to know. And then while I walk the mic over to Gary, what I would just like to ask all of you is, do you use track one for AI, and what has been your experience if you have? And if you haven't, then maybe you could say why you haven't, or why you haven't thought, or why your clients haven't found that. So Dan, maybe we can start with you.
Sure. Maybe I'll answer a little bit more broadly. We use every kind of filing in the toolbox. So yeah, track ones. I do a lot of work in bioinformatics, biotech, cancer immunotherapy pilots. Right? There's a bunch of special pilot programs for expediting prosecution of, certain narrow slivers of technology. The way those get classified and assigned, at least empirically, feels different to me. We do strategies like you file in the U.S. concurrently as you file a PCT application, and take a bypass or 371 off of the PCT application. It will land you in all sorts of places. Again, empirically, it feels to me that you're very likely to get into very different art units just by filing those same applications using those routes. So number one is diversity of examination. If it's in a very important application, we don't know which art unit is good.
Right,
you may get into an art unit and get an examiner in that art unit that is more challenging than, less challenging an examiner in a statistically on average harder art unit. But optionality to clients is really important. And what Drew said is right, at least for those clients that we work with that want to pay for track one, right, a large entity, that's another $4,000 ticket, right? So people who invest more in a patent application, those patent applications tend to have multiple claim sets, tend to have multiple aspects that could be claimed. Therefore, you can file things in parallel in lots of different ways. And we absolutely use that to kind of achieve this effect.
Was it difficult to convince your clients, or did they need convincing to do this?
It's really a function of how important it is to them, right? If they say, I just want to file a patent application, so I have a patent application, okay, well then it doesn't matter. If it's a really important case, it's a fintech, and they need patent protection because it's otherwise out there because it's going to be published, and it's important for their business strategy to have those things, and they're willing to invest in it. Then yeah, we would work up a much more sort of expensive and sophisticated strategy, but only if that reflects the client's needs and from the business side.
Yeah, thank you. Simon. Simon.
Right, so I filed track ones, but not for machine learning applications, and I think that speaks more so towards resource allocation.
Yes.
And so I believe that, in some of their opinions, it's more worthwhile to take that money and just draft more applications rather than trying to select and just hone in on a few. And I think that speaks somewhat towards our uneasiness towards Section 101. And to this day, as far as I know, I haven't seen much enforcement of machine learning models, so I think that's another question mark as well. We don't exactly know how this is going to pan out, so let's just try to file as many as we can, and let's just see which ones are successful, which ones are not. You also have the gambit of like 3,600, so for some applicants, it can turn more so into, let's file many instead of just filing a few very focused applications and spending the money onto, say, track one, for example. But I think that depends on the, tech field. I think in certain fields, like, bioinformatics and so forth, perhaps it's less inventions with maybe more focus and more strength behind those. And so I think it may depend on the applicant themselves, what their goals are, strategy, and so forth.
Yeah, for sure.
So, those are just my thoughts. I can't speak for all the applicants out there, but,
Yeah.
that's why I suspect it's happening.
Yeah, I have a very similar experience to yours, I think.
Yeah.
What about you, Mike?
Yeah, my clients are more or less in the same boat, and there's a lot of doubt. Everybody wants to have an AI patent portfolio, and nobody knows that it's valuable. They don't really know that these are going to be enforceable. It's no one's. There are a few companies whose products depend on it, but a lot of times it's the cutting edge. They're just trying to sort things out. It's not like a pharma thing or a situation where this patent's going to be super valuable.
Yeah.
And so that 8% additional likelihood of allowance versus the cost, the calculation doesn't always favor track one. And so that's what I've seen. My clients have not been eager to do that, so I usually don't.
Yeah. Mr. Commissioner, do you feel that the examiner's approach changes at all, depending on if this is, if this was filed foreign first or anything like that? No?
I don't think so. I think examiners look at every application in the same way. I don't think they necessarily, other than for understanding priority dates, look at a foreign filed or a continuation and say this one should get a different type of examination in any way.
Yeah. What about you, Dina?
So I have a mixed bag. I like filing a struck one, and for AI applications that are directed to AI itself, so changing or optimizing a model in some way, I think those are great candidates for track one, because you actually do have patent applications being allowed quicker. If I feel that the application can land in a 3600 art unit, I don't like to file track one, just because there were a few instances where I got an examiner from 3600 who had a lot of time on their docket, which is probably why they got assigned the track one case, because they were issuing 101 rejections, a lot of 101 rejections in their docket, and that was the only rejection in their other cases. And if you're using either patent bots or juristat, it's very easy to figure out why. So for 3600 type cases, I don't like to file track one anymore.
Yeah, there are just some examiners that have the reputation, like if I see them, I know not to even bother interviewing this case, because I'm just going to get angry, and it's not going to be a fun experience for anybody.
Well, that was actually, is my mic now? Well, I'm loud enough to, one of the things that I wanted to ask, do you need to keep financial words out of your AI applications the way that you would out of a typical software application? Because if the examiners, most examiners, if they think you're making money doing it, no patent for you no matter what it does.
So one strategy that I did, and I've actually had a client go ahead with it because it was a financial client, they were making optimizations to their AI model, and they were also applying it to financial context. So we ended up filing 2 patent applications on the same day. One is directed to the model itself, and the other directed to the model plus the financial context. And trying to sort of hedge our bets and see whether one is going to land in 3600 and when the other one would land somewhere else.
Well, and that's funny, when Dan was saying what he was saying, I just heard, not in the AI space, but in a biotech, it was either biotech or pharma. I didn't know who the client was. I know what the attorney does who told me about this, is that they had a client that they did not file on behalf of, but that they had done work with, and filed multiple applications on the same day that were almost identical, not identical, but almost identical, to try and look for, well, which examiner are they going to get that's going to be better, and will abandon the other ones. And knowing that they were just going to, right off the top, if it goes to any of these examiners that we can't work with, we're just going to abandon them.
And that's a general theme, and not just in sort of 101 land. to go back to trade secrets, right? AI is a big thing where you might want to keep it under the hood. We've had clients which said, I don't know if I'm comfortable releasing these details. And they said, but we want a patent. And we said, okay, well, you can try, but you might fail on enablement. So we've done things like file on the same day 2 patent applications. One has a non-publication request, and it's going to keep quiet and has a lot more detail. And the other one has a lot less detail. And the client is aware of the risk that, there might be some 112 challenges down the line. Right, and so same-day filings, different kinds of applications for different reasons is a pretty often used idea, and not just in 101.
And that's where track 1 it hasn't been mentioned yet, but track 1 is a testing ground.
Right, you see how the first one goes, and you see much quicker, and then you know what to do. Yeah.
Yeah, Rob, that was a good question for you as well. Are there any finance words that you know never to mention?
Like George Carlin's 7 words.
I believe it's hedging risk.
George Carlin, I'll just say this now, George Carlin has the best advice for being a patent attorney, possibly for being a contract attorney, as far as the use of language. But anyway, are there finance words I avoid? All of them, I think.
Yeah. But do you describe a purpose? How do you treat that?
No, I don't. And anyone I've ever supervised drafting a patent application, if I see that patent application, that background is full of issues about financial regulation or financial purposes, then that draft is going to be hurled back to them with great force through their email. Because if you build that, if you say that in the description that the purpose of the invention is for business purposes and financial purposes, you might as well just submit a 101 rejection yourself. So, and that's where getting to the point about inventor management comes into play.
Yeah.
You can tell them, I understand the business value of this invention. Focusing on these aspects of it is not going to be helpful for getting this patent application allowed.
And how do you handle describing the technological problem, technological solution, without mentioning purpose? Is that difficult?
Well, I've always, no matter what the technology, I've always been able to find a Federal Circuit case that, if not on point, I can at least try to analogize. Nothing's going to be 100%. There's no silver bullet. There's no perfect patent application. But most of the time, there's a way of presenting the invention that is a closer factual fit to various good case law on 101. And so what you do is you try to make the claims more like the style of that positive Federal Circuit decision. You look at what the rationale for finding patent eligibility was in that decision, and then you try to be creative and you find ways of presenting this invention in such a way that it serves the same kind of technical function that was found in the case law. That's not necessarily saying you don't put anything about the financial aspects in there.
Because I'm sure sometimes examiners ask whether you or your team, and what is this for? How are you actually going to practically use it? What is the practical application?
And the way I've tried to dance between the raindrops on that issue is probably on page 20 of a 30-page application, you will find some language. I'm giving away my secrets, but I don't draft patent applications anymore, so whatever. You will find the language. In one simplified example provided for illustrative purposes, this invention can be used for, and that's where you see language that is closer to.
And make it the third example, right? Give 2 other examples. And
No, not the third example. You get 3 examples. You put the worst one in the middle. You put the technical ones first and third.
Well, if Drew is right, the art unit determinations are now made primarily based on the claims. And so maybe putting some more examples in there in the meat of the application is not such a bad thing anymore.
Yeah, well, you'll find out in like 5
We'll
years.
find out.
So we have Gary's got a question.
Oh, yes, please.
So, truth be told, my question was actually answered a second ago. But I am really curious now, since we're kind of touching upon this subject. We see this technology we refer to as AI as a relatively broad application. And we're here discussing strategy, trying to manage the inherent tension between trying to get broad claims and at the same time trying to avoid the preemption rejections that you might get from an Alice rejection or even non-analogous art rejections that we might get under 103. So I'm curious, how do you guys manage that tension?
Yeah. Maybe I'll start with Brian on the side.
Yeah. I would say just good point to start in terms of rebutting some of those 101 Alice rejections is when a great Fed Circuit case comes down, of course I'll try and argue, but just keep in mind that most of your examiners are not attorneys. And when that case is digested in the MPEP, it's going to have a lot more weight to them. So I kind of not keep them in two separate buckets, but I really try to use the MPEP where I can because they cannot ignore that. We're not bound by the MPEP. They are. Of course, you have to look for that. Is it should or must, of course? Because if it should, then forget it, in my experience. So that's one thing. I did want to touch briefly on track one and give kind of a counterpoint to that. In my time at 3M, it's not necessarily a rush to the finish line to get that first patent with track one. I mean, if I wanted to, I could do a petition to make special in some cases. PPH, actually, fantastic article on IPWatchdog about it's a trap in some instances about getting out of it. Probably a topic for another time. But just, again, playing the long game, I like to see what's going on in the industry and let competitors, particularly, you know, there's a lot of competitors that were not even in existence when this was dreamed up by the inventors.
Yeah.
So it's more about where is this going in the long term and keeping those continuations, keeping something pending rather than just one and done with a track one. There are benefits, and I want a bifurcated approach. It was a great strategy Dan brought up about, you know, spinning off, well, going PCT route, but at the same time currently going with a regular U.S. non-provisional at the same time and seeing where that lands as well.
And do you ever purposely prolong prosecution just to keep it open?
Not for laches purposes, but
That was the only answer to that question.
Yeah, not to that point. But you know, if my docket's pretty full and I'm waiting till the end of the 3 months or so to speak, then a lot of times that'll happen. And same thing with the issue fee payments. And of course now with the electronic patents being issued, we don't have nearly the time that we used to file those continuations and divisionals.
Yes, very true. I saw a hand up. Was that you, Simon?
No, that wasn't me.
Okay. Anybody else?
I'll address the breadth question,
Okay.
if I may. So, you know, I guess I bring a different perspective because I'm not at this time actively prosecuting, but what I do see is people who are prosecuting call me, you know, sometimes people within my law firm, sometimes people, you know, outside of my law firm, and it's usually the same exact scenario where they're really upset. They have an examiner who they say is unreasonable. They've got these very detailed AI claims that the examiner won't allow because the examiner's view is that it's much broader than what the attorney says, and they want me to look at it. And I dive in, and I would say, not all the time, but probably 9 out of 10 times, I look at this and I'm like, okay, that's pretty broad. You know, like you might think in your head what you believe these said, but I get the examiner's standpoint. Now maybe that's because I was an examiner and I'm seeing it that way. I don't know. But to me, your question is an absolutely critical one because the mistake that I see people make all the time is they go so incredibly broad that they end up now walking into a 101. And if their spec doesn't have enough in it to be able to pull that back, they get in trouble, right? So I don't know if I have an answer for your question necessarily, but I do think that anybody drafting claims, this should be at the forefront of your mind about breadth. It will depend on your classification. It will depend on whether you get 101s potentially. I mean, there's so many factors that weigh in. So it's very important, but my advice to people is watch out for overbreadth. But again, there's a lot of people who have
I
different
agree with
opinions.
that 100%. We talk to inventors all the time and our clients about this idea of unnecessary breadth. So the simple example I always give is, let's say it's an image processing thing, it's got machine learning in it, and you start your claim, you're receiving an image. You're in trouble right away because when an examiner who's 101 minded looks at it, he says, oh, it's a 2 by 2 pixel, 4 pixel image. Of course that's not the valuable scope for your client. So why are you going to fight that fight? You could say something about a data structure representing a, image of a certain size, and yes, you can design around it by making tiny little images. That's not a commercially concerning design around. So things like that, we see that a lot in bioinformatics, receive sequence data. The examiner thinks, I open a page and it says ACGT. That is sequence data. You can do that as a mental step. It's in your head. Or you can say, gigabytes and megabytes of sequence data when you actually process a sample from a patient, right? And those are very different things. So we're all taught to just say it broadly, but recognizing that some of these things trigger the one-on-one analyses, you can actually think about whether you might be strategically narrow or kind of avoid that unnecessary breadth if your client doesn't want it.
That's a question I had, because when Mike and Rob were talking about the examples and where do you put the examples and that sort of thing, what do you do with your claim structure? Is claim one really narrow? Is claim one really broad? Or I know for some companies, I've been told by people who do work for Amazon, at least this when they told me this is a couple years ago, that they like to have as claim one, not the broadest, not the most narrow, but what they refer to as a teaching claim, that really kind of encapsulates what they really think the invention really is, step by step by step. So that's the first introduction to the invention by the examiner. They think they get better searches, they think they get better understanding, and they don't think they contaminate themselves for one-on-one purposes, whereas, like if you're like, you all remember the patent on the log, the stick, it was a stick the office issued like 20 years ago. Like if you file a claim and it's a stick, the picture, the drawing was of a log. I mean, they weren't really trying to hide anything. But if that's the message that you're sending with your claims, I think you're putting the examiner in the defensive right away. Well, this is one-on-one, and a lot of them, once they make up their mind of that, you're never going to convince them. So how do you address that from a claim structure standpoint?
So if I can comment in here. In the lead up to this, we had a discussion, and it largely focused on the breadth of the claims, and I think is a really interesting, and there's no 100% right answer, but I want to come in defending the broad claim concept. Because broad claims can just be more valuable than narrow claims. And in the aftermath of that conversation, I went and looked at some, just some random patents on Google Patents, and what I was seeing is what I'm afraid of, and what I see the output of many clients' patents are these, like claim one was like this long, and it had step after step after step after step, and my thing is that there's a big difference. You have like some kind of novelty in your claim, right? You got to have something that's like gonna make your patent, and you just need one of those. Mm-hmm. You don't need 12 steps. You need one good kind of novel, you need one invention in there, You don't need to write like every single little element of the process. You just need one thing that's gonna get you a patent. And then you have dependent claims if there's another thing that is kind of, patentable, and then you have a bunch of things in your spec. But I will say that as a matter of practice, I do something like what you just said, which is claim one is a story claim. I want somehow it to tell a story. I want the problem and the solution to somehow be evident in claim one. And I actually literally, when I'm training people, I say, okay, it's a three-part play. The first step of my claims kind of set the setting, maybe introduce some characters. The second one is going to be like the climax, the novelty, the thing that I want to actually patent. And the third one's going to be the resolution, the impact of that. How that's used. And so I think of my claim one as a story, and it's going to have some tension in it, and it's going to have one thing that is novel that I want to patent. And the rest of it, like, it's not going to be 15 steps.
What I'd like to do now is, and I know we're sort of like right in the middle of this, but this is almost kind of planned. I want to give us a break so we can get coffee, use the restrooms, and then we can come on back. And what I would encourage you all to do is think about what we talked about and think about your questions, and maybe talk with the panelists as they're getting coffee and stuff, so that we can, because I have this suspicion that the second half is going to be very directed and much more tailored to what it is you want to hear. Because I always, when I speak, people come up to me afterwards after you get done and they ask you a question like, oh, I meant to say that. So this is your opportunity to tell us what you want to hear them talk about during the second half of the program. And I realize we kind of focused on the prosecution strategy during that one, and that prosecution strategy was supposed to be for the second one. We will come back and talk about 112 and 101 and stuff, because I have some questions about that specifically, because I'll say this and then we can break for a minute. Years ago, when I was trying to teach students how to draft these applications, I knew some good friends of mine were doing real high-end computer stuff. So what I did is I went and I looked at what the patents were that they got, looking for that nugget that I could, pass on to the next generation. And the truth of the matter is there is zero nuggets. There was nothing to be if you focus on the claims. Because and this is where I got this idea that, so the claims are almost to some extent in this space incidental to the question, does your specification feel like you really even invented something? Because in the software area, it's too easy to write a specification that doesn't feel like you've done anything other than, magic here, magic there, black box there, output presto changeo, and a little David Copperfield, right? David Copperfield specs don't get patents anymore, if they ever did. So I think that the connection between the claim strategy and your disclosure is really the linchpin for software, and I suspect for many of your AI applications as well. And I want to talk about that when we come back, plus anything that you all want to talk about as well. So let's go get caffeinated, use the restroom, and be back in